Mr. N.K. Singh, please.
The timing, or is it including yesterday?
I think that there was no ambiguity about it. Today's timing is 2 hours and 56 minutes. We'll try to accommodate, but I do request everyone, because we have a process to go through at the end of it.
Thank you very much, sir.
No, there is a set procedure. Please go ahead.
Thank you very much, sir. It is an immense privilege to participate in this very important debate, and one must feel somewhat handicapped considering that one is speaking after two very eminent lawyers have already spoken at great length. My preceding speaker, Mr. Mishra, and of course, yes, three very eminent lawyers have already spoken on this, and the first non-legal luminary, so to say, given with the ordinary discipline, I would beg to submit before this House consideration 8 points for your submission, for your consideration, sir. First and foremost, clearly one is reminded by something which a very eminent jurist, Arthur Schlesinger, had said, that the genius of an impeachment proceeding lies in the fact that it punishes the man without punishing the office. This is precisely what this House intends to do through this very important motion moved by my senior esteemed colleague, Mr. Yechury. So yesterday, when I heard with careful attention the defense made by Justice Sen, I got three distinct impressions which I must share with this House. First and foremost, the impression which I got was he sought to create a false hiatus between the sovereignty of Parliament, seeking to bring it with the higher judiciary. He repeatedly quoted what has been happening by the higher judicial functions, as if to say that we would really stand up to the underdog in which he claimed himself to place himself in that position. I do believe, sir, that for the reasons which I'm going to give, that was a false hiatus and a somewhat misleading thing. My third important point, sir, is that in his entire defense, he sought to create straw enemies and straw allegations, which he then sought to destroy. What was that? For instance, sir, if you look at page 74 of his written reply, sir, he mentions about the fact that an order passed. Unfortunately, my explanation that these withdrawals were towards the payment of workers' dues pursuant to the division bench order, etc. Sir, it was nobody's case. Nobody had alleged that he was being held responsible for the payment of or the delay in the payment of workers' dues. So to demolish something which was initially never leveled against him is like creating straw enemies to be able to then answer that in his own way. Similarly, sir, I think that in the Inquiry Commission's report, clearly, sir, that he has sought to alter the meaning of misappropriation. My esteemed colleague, Mr. Mishra, has dealt greatly with the meaning of what he believes is misappropriation. As a trustee, sir, it is clearly understood that the money which he received was to be held in trust. That trust enjoined upon him a responsibility that he could not divert the proceeds of that trust into some other account. He could not use, for instance, for his personal purposes, no matter whether he reimbursed it subsequently or not. As a trustee, sir, there are certain obligations which are cast upon him, and therefore, by any attempt in his defense to alter the meaning of misappropriation, in my view, is flawed. Also, sir, his suggestion in his defense yesterday, and that's my next point, on biases and predilections of successive higher judicial authorities, and by successive inquiries which were held, in my view, did not seem to be borne out, considering that he himself had not cooperated with any of the processes. If you look, sir, at the successive adjournments which he sought, where he failed to appear himself personally, where he really appeared through his attorney in sometimes really giving petitions in the name of his mother, in my view suggests that the suggestion of bias and predilection looks to be flawed. My next point really, sir, is about the credibility and the integrity of the processes and procedures which were followed before these judicial findings were reached. I do not think, sir, I believe that anything which he has said in his defense casts any doubt on the procedures and credibilities. I agree with you, sir, that a judge is not supposed to know anything about the facts of life until they have been presented to him in evidence, and as has been said by very eminent jurists all over the world, explained to him at least 3 times. Indeed, sir, they were explained to him more than 3 times. Sir, the findings which have been received in this clearly are findings in 2 parts. One, as very rightly pointed out by my esteemed colleague, Mr. Mishra, his conduct as an advocate. But as an advocate, he knows better than I do that you are enjoined upon as an advocate to follow the Advocates Act. And what did his conduct mean? What he did under the Advocates Act? It comes to a conclusion, was conduct most unbecoming of an advocate. There's a part 2, which then deals with his conduct as a judge. Therefore, sir, in the findings which have been reached in the concluding paragraph, the part 8 of the Inquiry Committee report on the misappropriation, duly proved, this is in 2 parts, in his conduct as an advocate and in his conduct as a judge. Go to my last point, which is about some of the broader issues which this adjournment, with this impeachment motion has enabled this House to deliberate for the first time. The area, sir, of stalled judicial reforms. So India is seeking to become a major economic power, is seeking to achieve over 8% rate of growth. Whether we go to John Rawls' theory of justice, which really wants to seek an explanation on that inequalities and certain kinds of economic deprivation can only be tolerated if it benefits all sections of society. And that, whether we must ask ourselves the important question, whether our present judicial system is adequate to meet India's changing economic realities in terms of improving, and the Prime Minister knows it better than anyone else, improving our climate of investment, on transfer of properties, on mergers, on pricing, and a whole host of things in addressing it in a manner which really would enable this country to go. Managing rapid economic changes, sir, while maintaining the social cohesiveness of a social order with a 9% rate of growth, is our judicial system equipped to do so? Indeed, sir, as in very rightly pointed out by the Honourable Leader of the Opposition, that this impeachment motion has given us an invaluable opportunity to consider some of these things beyond narrow partisan confines. Sir, I strongly believe that the appointment of a National Judicial Commission, I strongly believe that the demarcation of responsibilities between the 3 functions, indeed many of us, sir, were shocked, and I'm sure many of us would have been shocked when certain judicial pronouncements were made which questioned the Parliament, which questioned, for instance, whether it was necessary to attend Parliament, which questioned the integrity of this very vital organ, sir, which is the overarching organ of our Constitution. Many of us, sir, were so appalled, many of us were ashamed to be part of a process when it was pronounced, and Parliament as a whole, certain aspersions were being cast on Parliament, and we were, sir, a mute spectator. Indeed, sir, if we do not consider this opportunity to the major issues of judicial reform, setting up a judicial commission, a better demarcation of responsibilities, a better examining of whether our present judicial system equips us to deal with rapid economic growth, with issues of poverty and inequality, we will miss, sir, a very important opportunity. I therefore, sir, support this motion. I support it because I do believe that in the end, if we do not maintain justice, justice will not maintain us. This was a very important saying by Francis Bacon in 1615 at the impeachment of the then Attorney General in the House of Commons, and we must be reminded, sir, of this. We must be reminded also that it is how easy it is to judge rightly after one sees what evil comes from judging wrongly. We must, sir, judge rightly. We must exercise the sovereignty of this House. We must not allow this valuable opportunity to slip our way. I support this motion. I support also the opportunity of this motion to bring about a kind of qualitative change in the way in which the demarcation of powers between the three